Hello everybody and welcome to this new Privacy Rules webinar session. My name is Alessandro Di Mattia. I'm Legal and Executive Assistant at Privacy Rules. And today I'm joined by many of our colleagues from different countries. We have Ruth Ng from Singapore, Kelly Dickson from Australia, Peter Szanislai from Hungary, Europe, and Pádraig Walsh from Hong Kong. The reason why we have united all those members is that in Hong Kong, we just had the proposal for a new data privacy law, and the commissioner has examined different jurisdictions in order to make this proposal that are exactly the jurisdiction that we have represented today. So this webinar will discuss about the proposal. In the first part, we are going to discuss about the draft proposal. In the second part of the webinar, we are going to see which are the parts that the proposal didn't address, but are already addressed in the regulation of the other countries in order to give some tips also to the regulator. So without further delay, I would like to leave the word to Pádraig from Hong Kong in order to have an overview on the regulation and then move with all our members in order to have a discussion on it. Thank you very much, you all, and thank you for listening to us.
Hi, Alessandro. So just to maybe give a little bit of an intro in terms of what's happening in Hong Kong and context first. So the data protection rules and regulations came into Hong Kong over 20 years ago, or in 1997. We've had one refresh since in 2012. But tech moves fast, and really in terms of keeping a pace with the change, a couple of events and incidents have happened which showed that Hong Kong was behind the mark. So now there are proposals to bring forward roughly, 5 changes which are of international relevance for the purpose of this discussion. Running through those quickly, there is a recommendation for bringing in a mandatory data breach reporting obligation to the Privacy Commissioner. There is a recommendation that data controllers and data processors would be brought directly under the regulation of the Privacy Commissioner. At the present time, data users are, but data processors are not. There is a proposal that all data users, the equivalent of data controllers under GDPR, must have a written data retention policy and also would then be held accountable for their compliance with that policy. There is a proposal for a change to the definition of what is personal data, or what's called personal information in some jurisdictions. So the consequence of which is it's likely to bring in more of the online digital tracking identifiers into the direct regulation of the Privacy Commissioner. And the final proposal for change is to give the Privacy Commissioner administrative fining powers and authorities.
Okay, perfect. Thank you very much, Pádraig, for this brief introduction on what's happening there. I would like to start with the closest country to Hong Kong, that is Singapore, so to Ruth. I would like to ask you, Ruth, at which stage is the current regulatory framework in Singapore, and if there is a mutual influence between your country and Hong Kong in the creation of data privacy laws?
In Singapore, we are similar to Hong Kong, also reviewing our personal data protection laws. The last 1 or 2 years, we've seen about maybe 2 or 3 consultation papers being released by the Personal Data Protection Commission here. And there are quite a few similarities with Hong Kong's proposals, such as introducing the mandatory data breach notification regime. And I think whether Singapore is influenced by, we're mainly influenced by international trends and recommendations from other countries and whatnot. I think that the greatest similarity though with Hong Kong is that they're both regimes that are very much driven by a need to be business friendly. So in that sense, you may see a lot of similarities and perhaps inspiration from both jurisdictions.
Perfect, Ruth. Thank you very much. And Kelly, to you, we know that also the Australian regulation has changed a lot in the last period. Where do you think that the Australian law may have helped the Hong Kong regulator to create these new proposals, since they say that they have considered also the Australian regulation?
Yes, hi there, Alessandro. I think that the Australian experience in some way mirrors the Hong Kong experience as well. We've had privacy laws for quite a long time, 30 plus years. Uh, they weren't great, and we've recently, since about 2014, been going through a process of quite significant change as well. So I think that there's been a lot of learnings to come out of the Australian experience. We haven't got to the stage of some of the proposals that have been put forward for Hong Kong, but I think that certainly our mandatory data breach regime was an area that was looked at quite closely. I think that the Hong Kong proposals in relation to the definition of personal information is quite close to what we've gone through as well. So I think that there's really been three areas. One is probably the definition of personal information. The other one has been our experience with fines. In Australia, we started out with 0 fines, and recently those fines were increased to 2.1 million Australian dollars in a worst case scenario. So we aren't anywhere close to the GDPR type of fines at the moment, but slowly I think we're all getting there with that. I think the third one, as I said, is the mandatory data breach regime. But even there, the Hong Kong learning and the proposal for Hong Kong is quite different to what we have in Australia.
Okay, definitely, it's right. And Peter, to you, it's evident that the GDPR is, in general, one of the regulations that is inspiring all the other countries in the creation of data privacy laws. Can you detail for us and for the audience which are the main similarities and main differences with the regulation there in Europe?
Yes, so we can see several similarities between these elements of the proposal, with, I would say, some small differences in the details. So in the European Union, there is also this the mandatory data breach reporting mechanism. The phrasing of it in the GDPR is different from the proposal, as I understand, because under the GDPR is the main rule that breaches should be reported, while in my understanding, under the proposal, only breaches which pose serious risk should be reported. Otherwise, the definition of personal data is very similar. So the GDPR also talks about any kind of information which is related to an identifiable natural person. And as to the data retention mechanism, I would say that this is one part of the obligations under the GDPR. So data retention policies should be maintained, but the data retention should also be communicated to the data subjects. Besides about the direct accountability of data processors, under the GDPR rules, basically the data controller, or in the Hong Kong wording, the data controller is the one who is responsible for the data processing itself. But obviously, data processors have also obligations of maintaining data security, and the data controller is obliged to carefully select the data processor. And of course, about the fine powers, I think that this is very well known all over the world, that there is also a maximum amount of fine, and also the fine is defined in the percentage of the annual turnover. So as a summary, I can see really a big amount of similarities with the GDPR and the proposal, of course, with differences in details.
Okay, perfect. Thank you very much, Peter, for your brief overview and discussion. And Pádraig, are there any questions that you would like to raise? I'm considering that there are some points that are different from one country to the other, but is there one in particular that you may want to raise to discuss with the members that we have today?
Well, maybe just to reflect back on some of the points that have already been made. The point about a mandatory data breach obligation, that as a general concept and principle, I think many people would agree that it's a good idea, that if something goes wrong, you tell authorities and you tell the people affected. But one of the things that's coming through in respect of the way the proposals are being considered and formulated is it's actually quite a complex issue. So should you notify people, for instance, the data subjects, before you're in a position to maybe give them proper information about what the scale or what the consequences of the data breach are? So, whether there should be a different type of notification regime towards the regulator as opposed to towards data subjects themselves. How long it should be? Should it be if you lose, one small piece of data, or should there be a threshold? Is there a materiality threshold? If so, how do you decide whether something is material? So there are actually quite a lot of complex issues involved in that basic proposal, even though the concept and the underlying principle is something that many would agree with. And the other thing that I think is good to reflect on is around defining potential. If you look globally around privacy protection, privacy enforcement, you tend to have two streams of approach in respect of that regulation. One, which is more of an emphasis on education, control, building the culture, almost like a not approaching the regulated persons with big sticks, but more looking at the carrots and the incentives towards having good policies and good procedures. And the other approach, which does have the ability to impose fines and penalties. And I think what you're finding globally is that there's a trend towards recognizing that you will not be able to influence the culture of data users or data controllers, companies basically, in respect of the personal data that they hold, unless you also have the ability and a mechanism, an efficient mechanism, to have some kind of a stick, some kind of an enforcement threat, because that is one of the drivers towards achieving better compliance. So it is interesting to hear the different experiences, and virtually across the entire range of speakers, you have a situation where countries either already have these principles in place or are actively considering them.
Yeah, perfect. Thank you, Pádraig, for this proposal. And I would like to start in the opposite side this time. So I would like to see what Peter has to say on this. And it's interesting also because we had the opportunity with Pádraig to discuss already about the data breach, the Cathay Pacific data breach, in relation to another data breach that happened in Europe, in the UK, that is not Europe anymore, but it was at that time, and there was a really different way and a different approach to the data breach from one regulator to the other.
Yes, so about this data breach mechanism, actually, personally, I think that I already mentioned the difference of wording, that according to the Hong Kong proposal, only those breaches should be reported which pose serious risk, while under the GDPR, it is the main rule that breaches should be reported. And my own experience as a practitioner is that companies often have minor breaches, like sending a couple of emails to wrong addresses, or this level of problems, which they always try to avoid reporting, because obviously this would mean that they report themselves to the supervisory authority, and they have the risk that they would have some reputational harm or some kind of fining. So, while on the other hand, those types of breaches which happened with the British Airways, which are obviously a major risk for a huge number of data subjects, those ones should certainly be reported, and in that case, the sanctioning, which is probably, actually it is so far the highest amount of fine imposed under the GDPR, I think is completely reasonable. So, as Pádraig mentioned, it is very important for the regulation to keep some balance. And I think it is also a matter of legal interpretation, both from the sides of the data users, data controllers, and from the authorities, which types of breaches they consider as significant enough to be reported. And I also think that this 5 business days deadline in the proposal, in terms of just measuring the possible impact, probably that type of deadline is a bit more reasonable than the 72 hours under the GDPR. So these are just my comments on this topic.
Definitely, definitely. This last point is a very good one. I agree on that. And Kelly, what about Australia?
Well, I think that is one of the really big differences. To the point about the time frame, under our new mandatory data breach regime, which only came in 2018, so it is still quite new for us, the threshold is that there needs to be an unauthorised access to or disclosure of the information, and it needs to be that it is likely to result in serious harm. So that's the threshold that we have in terms of determining what the risk could be and what's the level for reporting that. Our time frame for reporting to our Privacy Commissioner and also to affected individuals is 30 days. So you've got the GDPR at one level that is 72 hours. You've got Hong Kong proposing 5 days in the middle, and Australia seems to be lagging quite a far way behind in relation to a 30-day period. But I think going to Pádraig's point in relation to, do you notify everybody? If you do a notification, do you actually have a resolution that you can give to the affected data subjects at that time? I think the Australian 30 days might help with that, because you've actually got a longer period of time to work out what has happened, what's the data that has been compromised, who's involved with it, who do you really need to tell, and start to do that assessment of the threshold. So I think that helps. But to Pádraig's point about notifying individuals and having a slick, good solution for them to follow versus being required to give them the information when you don't really know how to sort it all out yet. Let's not forget in that there's big reputational issues that come as well, because if you don't have a cohesive, good PR response to put forward, that can have a lot of reputational issues and cause a lot of damage down the track.
Okay, but that's very interesting, Kelly. Thank you. And Ruth, what about Singapore?
So in Singapore, while we don't have mandatory data breach notification as part of law, the PDPC did release in July 2019 a guideline of sorts that require data breach notification as good practice. And it's quite informative because I guess it's meant to pave the way for the eventual changes to the law. And it is quite similar to what I think Hong Kong is doing, where businesses will have no more than 72 hours to notify PDPC of the breach. But I think the interesting point is when it comes to notification to individuals, there's no real time frame to it. It's currently as soon as practicable. What businesses are encouraged to do here are to notify PDPC first if they're unsure about whether they need to inform individuals. So it's a bit of the situation is a bit more, I feel, business friendly because, from a business perspective, it's hard sometimes for them to conclude whether the breach will cause significant harm, is there significant scale. So PDPC stance is come and talk to us. We can look at it, we can analyze it together, and we can advise you and guide you, which helps a lot for the local businesses.
So you are also confident that your regulator will maintain this business-friendly approach that is typical of your area. I think we faced something similar also in South Korea and of course in Hong Kong, as we have seen, is in that area the business-friendly approach is the most followed one, and I can understand why. For sure. And let's move to the second half of our discussion of today, that is related to what has not been addressed in the Hong Kong proposal and that maybe is addressed in the other countries. Pádraig, I would like to ask you what kind of additional provision are the Hong Kong data privacy lawyers looking for?
Well, I'm not sure that privacy lawyers are necessarily looking for them, although they might welcome them for the additional work that might be involved. But I think one of the things that is interesting, and it touches back to Ruth's comments, is that where you're in jurisdictions where there's a business-friendly approach, you almost discern that as much from what is not being done as opposed to what is being done, and that's where the balance is. So some of the things that aren't being addressed in the new proposals are to draw a distinction between what you might call general personal data and sensitive personal data. Sensitive personal data being maybe requiring a higher degree of protection. There's no particular provisions that are going to be directed towards children's personal data, and you see that in some jurisdictions, in some other jurisdictions. A couple of the prominent things that came through with GDPR were the so-called rights to be forgotten. So the ability of the data subject to say, delete the personal data that you have on your systems in relation to me. That's not being proposed. You will still have rights to have access to and to request correction of, but not to require deletion of. There isn't a proposal in relation to data portability. Also, for a long time, actually since 1997, there's been a provision in the ordinance around regulating international transfers of personal data. So making sure that if you were moving personal data outside of Hong Kong, that you were doing so to equivalent jurisdictions, or you were sure that the personal data was going to have the same level of protection, security, and so forth. There's no mention of a time frame for that particular provision to come into force as yet. And there's no change in the underlying principle that we operate under inform people of what you're going to use the personal data for at the time of collecting the personal data. So it's an inform first as opposed to a consent first principle in terms of the collection of personal data, with a couple of exceptions, but primarily it's inform first rather than consent first. And there's no proposal to change that either.
Okay, thank you very much, Pádraig. And Kelly, considering the points that Pádraig just raised and what we have said before, where do you think that the Australian regulation may be helpful for future developments in the Hong Kong data privacy law?
In a sense, I think that some of those parts of the Hong Kong law changes that are missing are a little bit surprising. In Australia, we do have a strict definition about what is personal information versus what is sensitive information. So sensitive information, as Pádraig said, does need to be treated with a higher level of care, and the consent requirements in Australia for personal information versus sensitive can sometimes be different as well, because sensitive information needs a higher level of care and protection. So in Australia, sensitive information is things like race, ethnicity, religion, health information, criminal record, political associations, and those sorts of things. So where in Australia we can generally use personal information in a lot more free manner, the sensitive information has a lot more requirements and restrictions around it. So that's surprising that that doesn't really feature because it does seem to be a fairly settled part, I guess, of many other regimes as well. Where some things are interesting in terms of the journey that Hong Kong is going on too, in Australia, we don't have any specific privacy regulation around children's data. That has been proposed in Australia as well, but we're not quite there yet either. On the flip side, as far as transferring data offshore goes, we do have some requirements around that. And so I think that that's been an interesting omission as well, given just the global nature of business these days and the fact that many businesses transfer their information offshore, they store it offshore and all sorts of things like that. So one of the areas that I think that Hong Kong might be getting to as well, and maybe this will be an area that the privacy lawyers really will love, relates to data portability. Now, in our privacy regime, we don't really have any of those rights to portability. Like Pádraig said, you can access information, you can correct it, You can ask for your information to be erased, but there's no right to be forgotten. But Australia has just very recently implemented a new regime called the Consumer Data Right. And it's quite an interesting regime that sits a little bit separately from privacy, but that is where our real data portability comes about. So I might at the end make some comments about the Consumer Data Right and some of the learnings that we might see in this space, because I'm keen to hear from Peter about some of these other similarities and differences too.
Perfect. Thank you very much, Kelly. And Ruth, considering that, as we have seen, the Singapore regulation and the Hong Kong regulation share some ideas behind it, I would like to ask you if you have 2 or 3 tips or recommendation that you would give to the Hong Kong regulator to continue in the drafting of the new law.
I think the first tip is not so much for the drafting of new law, but it's more of a practical thing, which is that once the commissioner gets the right to administer fines, I think it's a good practice for the commissioner to also release the grounds of decisions for the different fines that are given out, because that's what we do in Singapore. And I find that these decisions are most instructive, because I think the nature of privacy law can be quite principle based. So businesses will have a hard time understanding how does it apply to them practically. From these decisions, we actually see in real life circumstances how what the commissioner deems as, for example, what's reasonable security. In a recent Singtel case, where one of our telecoms were found to have not sufficient security, they actually went quite deep into details of what sort of testing should have been done. So that was very helpful. The other thing that I think Hong Kong and Singapore would be similar in is introducing more regulations to set out how big data should be carried out in the country. So in Singapore, we are considering certain provisions within our data privacy laws that will allow more big data analysis to take place in our businesses. So in short, our data protection exception will allow businesses to use personal data without customers' consent or without having to inform them beforehand. But that is in a very limited circumstances to improve and optimize the business and to have a better understanding of consumer needs. So that is very business friendly. I think that's something that Hong Kong would potentially be interested in as well.
Okay, perfect. Thank you, Ruth. And Peter, as we all know, probably the GDPR already covers most of the points that have been raised at the beginning from Pádraig. And based on your live experience as data protection practitioner, which one do you think are maybe particularly effective and useful as possible guidelines for Hong Kong?
Yeah, so I would first definitely mention the international data transfer regulation of the European Union, which could be used probably as a guideline because it is a very sophisticated mechanism. Basically, the controllers can choose between many options if they want to make sure that they are allowed to transfer personal data to other countries or third countries, as we call it. For example, one of them is that there are some standard contractual clauses which should be included between the transfer and the transferee. And if those are included and followed, then in this case, the transfer would be allowed without any further problems. But of course, there are other mechanisms like using binding corporate rules or checking if the European Commission has an adequacy decision about a certain country, which country has the adequate level of protection of personal data, and then transferring data to that country would be also fine. So there are lots of options from which a controller can choose if he wishes to transfer personal data to third countries. Another thing I would mention is actually quite interestingly, and this is probably not a well-known fact for practitioners outside the European Union, the GDPR basically brought more lenient rules or kind of easier solutions for many member states because it provided several legal bases for the processing of personal data. For example, in many countries before the GDPR, a consent was mandatory in almost any conditions, or alternatively, if there was an actual legal rule which ruled about the data processing. So these were the two options. But with the GDPR, there are other legal bases like legal interest, a lawful or legitimate interest, as we also call it. And this means that there are more possibilities to ensure the legality of data processing. I am wondering if these alternative legal basis or this kind of regulation that the list of legal bases are provided by the regulation, and then the data controller or data user can choose on those and also communicate it to the data subject. This can be probably used in the future in the Hong Kong regulation as well.
Perfect, Peter. Pádraig, lots of interesting consideration, I would say, on how to move. Do you have any thoughts that you would like to have?
Well, I'm going to set up my appointment with the Privacy Commissioner now and tell him what he needs to do. He's going to hear it from PrivacyRules. I think what's interesting also is that a lot of the points that have been made from the various speakers, the Privacy Commissioner here has been a very strong advocate for good, good privacy conduct and personal data protection, security, all of that. He's been very, very strong in terms of his communication. And the volume of guidelines and circulars coming out to give an indication of what his interpretation of what best practice is, there's a significant amount of material that's out there. What I think he has been lacking has been the statutory power, the statutory backing to be able to do more than just ask people politely, more or less, what they should do. So even in respect of international data transfers, there's a very detailed guidance note in respect of what companies should do in that situation. But at the same time, it's a best practice guide as opposed to a statutory requirement. So you might get into trouble with the Privacy Commissioner if you don't follow the best practice guide, but it's not necessarily a statutory offense. And sometimes those gaps in a consistent approach to enforcement have caused issues. Funnily enough, and I think Ruth might find this amusing, the last that was heard in respect of the whitelisting of jurisdictions under international data transfer proposals that the Privacy Commissioner was bringing forward is that only 2 other jurisdictions in Asia were likely to get onto the white list. Now, at that time, the thinking was it was probably Singapore and, for obvious reasons, mainland China. So we'll see whether that's the case if it ever comes through.
I'll be surprised with the results, but I'll look forward to it.
Yes, Ruth, since we were speaking about Singapore, do you have other concluding consideration you would like to move before ending the discussion?
I think maybe the one other thing I would like to bring up shortly is Singapore is considering data portability, but I do think that the nuance, that the motivation for Singapore is slightly more business oriented. So for my impression, correct me if I'm wrong, Kelly and Peter, but is that other countries want to introduce data portability from a consumer protection perspective or pro-consumer perspective, whereas in Singapore, there is a sort of school of thought that it is good to introduce this sort of competition in the market to allow business to flow better, or rather to reduce competitive practices. So I think that is something that Hong Kong would also. I wouldn't be surprised if Hong Kong goes down that path in the near future.
Yeah. And Peter, Kelly, speaking about what just Ruth mentioned, do you have a reply, something that you would like to add?
I'm happy to go first on this. I think that Ruth is absolutely right in relation to the data portability issue. And I think that that's been a really interesting change of focus in Australia. we have always looked at privacy almost in a bubble, in its own little silo, in relation to reviewing a privacy policy based on what are the privacy implications. But with our consumer data right, it's actually a lot more focused on the competitive benefits that can be created for businesses when data is able to be shared around between businesses, particularly for the consumer protection and the consumer benefit side of things. So some of the issues there are just about giving consumers more control over the data that is held about them and who that data is then shared with. But what we're also seeing in Australia, and it will be interesting to see what other jurisdictions do, is that our consumer data right, our lead regulator on that isn't the Privacy Commissioner, it's our competition and consumer regulator. So in Australia, we're really starting to see now that privacy issues aren't just about privacy, they're about making sure consumers have these rights, making better efficiency in markets as well. But privacy now will be more about, are your data collection practices fair? Are they misleading? The content of your privacy policy, is it fair? Is it misleading in the way that it says what you're going to do with people's personal information? So that's actually the way that our privacy is also heading as well. And our consumer data right as well doesn't just apply to individuals, it can also apply to businesses. So privacy at the moment is growing, it's changing very rapidly here in Australia.
Thank you very much, Kelly. And yes, Peter, we can see that there are two different approaches on privacy. Which one is the one of Europe, in your opinion?
It is really very, very interesting what Kelly just mentioned, because that's exactly what I also wanted to say about my jurisdiction, which is also very interesting from the point of view that consumer protection authorities and competition authorities began to pay attention to data privacy, obviously from somewhat different perspective. For example, I think I can mention one case. Now, in my jurisdiction, there is a consumer protection authority procedure against Facebook. And the basis of this is Facebook used to have the statement of providing its service for free, while the Consumer Protection Authority states that if consumers pay by handing over their personal data, that means that it is not a free service. So we can see that, and it is very, very debatable, and this is not final and binding decision, but we can still see that Consumer Protection Authority began to use a kind of data protection related or data protection originated argument to just use it for consumer protection purposes. So it is very, very interesting to see this interaction between these two legal areas, and probably we can expect also in other European jurisdictions as well that similar things to this might happen.
Yes, definitely. It's something that is popping up all around Europe. I can see it already in Italy, for example, and also in other countries. That's the approach that started everything from the European perspective. That was the one to protect consumer, and in particular protect consumers from their data being sold without their knowledge. And you know, there are also proposal of actions to have back the money that some companies have reached thanks to the data of the consumers. So that's really interesting. Thank you, Peter. And Pádraig, we are running out of our time, so I think we can move to our concluding remarks. I think it has been a very interesting discussion, and I thank all of our members. I don't know if you want to say something more just as a conclusion of this very interesting discussion.
Maybe just in conclusion, it's always fascinating to hear the international dimension to these conversations. Data itself moves internationally, and even though there are changes in the laws in one particular place, what's really happening globally is a convergence in where those laws are roughly going to be. But you can still hear from Australia, from Hungary and the EU, from Singapore, from Hong Kong, there are differences wherever you are operating. So it's still, you know, a good recommendation to check in with your local advisor to make sure that you're compliant in respect of where your laws are on these particular points.
Definitely, definitely. So, Pádraig, Kelly, Ruth, and Peter, I thank you all very much for being with us, and I thank all our listeners for following us today, and I invite them to follow Privacy Rules and all your great firms that they will see in our infographics. And I thank you again, and I hope to see you all very, very soon again. Bye-bye, everyone.